Okay, we are your last panel of the day, which is to say we stand between you and Andy Gavel and Harry First making some very profound summing up remarks. And they stand between you and the cocktail hour, which is to say, I suppose, plug away, Randy, the quest for next. So, one quick note. This morning, we opened by noting that there were a lot of things that didn't exist back in 1998 and 2001 when the Microsoft case was being tried and the appeal was being argued and issued. There are two very material things that existed then but don't exist now. No spoiler alerts necessary. Netscape and Internet Explorer. If you still have the icon, trust me, it doesn't work. To remind you all, our panel's mission is this. When Judge Kolar-Catelli initially decided to limit the remedial decree in Microsoft to 5 years, she predicted that by then the market will have moved on from Windows and the browser to, quote, more advanced technology. But did the market do as she predicted? This arguably failed prediction reminds us of the challenges of directing competition policy and enforcement with an eye toward future developments. Will the current wave of monopolization litigation meet that challenge? Our panelists will answer that. To what areas should antitrust enforcers and policymakers pay attention in anticipating future market and technological developments? Very simple query, right? How should it seek to resolve the already evident need to account for AI, content moderation, and privacy? And what other issues might confront an antitrust policy that seeks to promote both competition and innovation? So no precarious prognostication is involved at all on our panel, but we are able to dive right in with four panelists who are up to the task as cleanup hitters. And I note there are four panelists, two of whom are ladies. I will start from my left, your right, so read in Hebrew with me. Luke Streetfield is my partner in Housefeld's London office and New York office. This is when I really feel inadequate in introducing the four of you, who currently advises the proposed class representatives on the £7 billion UK claim against Google for abuse of dominance in search, is also one of the lead partners in the first historic consolidation of £13.6 billion in claims against Google for abuse of dominance in ad tech. Avi Goldfarb is the Rotman Chair in Artificial Intelligence in Healthcare and Professor of Marketing at the Rotman School of Management, University of Toronto. Avi is also Chief Data Scientist at the Creative Destruction Lab, a research lead at the Acceleration Consortium, and a research associate at the National Bureau of Economic Research, where he co-organizes the Digital Economics and AI Initiative. Thank you for sharing some of your free time, Avi. Erica Douglas is an associate professor at Temple University Beasley School of Law, focusing on the intersection of antitrust, data privacy, and intellectual property law, with particular emphasis on the application of legal theory to new technology. Prior to joining Temple, Professor Douglas practiced antitrust and technology law at Covington and Burling's Silicon Valley office. And in her degrees, LLM and JD in Honors in Business Administration, come respectively from Stanford and the University of Western Toronto. Avi, Erica, and I have not discussed last night's hockey game. And Eleanor Fox is a legend. She is the Walter J. Derenberg Professor of Trade Regulation, Emerita. You wear it much better than everyone else. Here at NYU Law, a renowned expert in international and comparative competition policy, an appointee to antitrust and competition advisory committees by multiple US presidents, and the holder of numerous lifetime achievement awards, to put it very, very succinctly. So, as it turns out, the world didn't move on from Windows, but it did move on from Internet Explorer, which was retired in the Conley v. Gibson sense 3 years ago. Its successor, Microsoft Edge, currently has a market share of, I don't know, Randy would correct me, 3 or 4%. Google Chrome, of course, holds the lion's share of the market, and Safari, for those of you who like the walled garden, is preferred perhaps by up to 25% of users, but it's used much less. My question is in two parts for all of the panelists. The first part is specific and optional. The second part is not, because it's effectively looking for your opening statements, as it were. First, until last year, Microsoft's bundling had largely escaped renewed antitrust scrutiny in the US. But the EU has looked at those practices, including Word and Excel and other Office products, and more recently, Teams. Should we be more concerned here concerning Microsoft? And more generally, this is the mandatory part, what keeps you up at night when you're thinking about big tech and why? And in this instance, we will go by order of Supreme Court portraits. So I will turn to you first, Erica.
Thank you. It's such a pleasure to be here. So I keep a list on my laptop of quotes that compare antitrust remedies and litigation to wild animals. One's from my boss at Covington, my former boss, Tom Barnett. He said it's like remedies are like what to do after you catch a tiger by the tail. Microsoft, of course, famously sort of said it's like whopping a mule upside the head. And I was so pleased to get to add to my list because John Baker pops up like a cicada to discuss Microsoft every 15 years at NYU. Since Microsoft, this zoo has a new animal, data privacy, depending on where you're from in the world. And so that's what keeps me up at night, the big, hairy questions about privacy that are lurking within the antitrust context and within competition policy. Like, we all know that we're here for this conference because we're at this inflection point in controlling digital power. And in the US, I fear that privacy is not being well understood in the implications for competition. So for those who don't stay up at night thinking about these sorts of things, I think the simple explanation is that we recognize from this conversation and others that data has become fuel for digital competition, and some of that data is our own personal information, identified or identifiable to individuals. Antitrust is regularly seeking to restore and encourage data flow, and at a simple level, data privacy might seek to limit those sorts of flows. But if we look back to Microsoft, we know that consent decree also ordered data access, disclosures of APIs and protocols to encourage competition. And we could go back even farther, as we have here today too. In 1952, IBM was ordered to disclose technical information about tabulating machines and cards. So what's so different this time? IBM, Microsoft, that was company data, created, owned, exclusively controlled by those companies. Today, when personal data is at stake, there's an element of co-control by individuals, not just the defendant, and this growing array of privacy principles and laws that we don't know really what to do with in antitrust. So how do we think about it? And we'll talk more about the details of this, but this new era of big tech litigation, and particularly remedies and what they mean for our privacy. I think it's first worth remembering that even in Microsoft, when company data was at stake, there were exceptions where APIs were not required to be disclosed if they had data security implications. Okay, so we might need some careful exceptions for data privacy at times and remedies. And second, the idea that privacy is not just, although it's an accessible point, appearing at the remedies stage, that it's popping up across, to my great delight since I write about it so much, across all of antitrust law in a variety of forms, right? The FTC is alleging that Meta used its monopoly power to erode privacy in social networking. Judge Mehta was skeptical of these sorts of arguments in the Google search case. We saw in Epic versus Apple, the Ninth Circuit confirmed that design choices that improve privacy competition may be a pro-competitive justification, and Google picked up on that reasoning, although they didn't quite get it right, in the ad tech case. So the relationships that are happening here between antitrust and privacy are increasingly complicated, they're variable, They can be complementary or in tension. And I think thoughtful digital policy is going to be pressed to seek both or to come up with principles on which trade-offs between the two can be logically and comprehensively decided.
Thank you, Erica. Avi?
Okay, I think I'm here to talk about AI, and so I'm going to talk about AI. So AI, in my view, is a technology that has potential to transform the way we live and the way we work for the better. That's been a core theme of my research for the past 5 years or so, if not more. An essential worry for me is that we're actually not going to have enough AI. And so what might slow AI's diffusion, given where we are? It might be obvious that I am worried about competition. I'm worried that a small number of tech companies might control AI and either throttle its development or direct the technology in a way that serves their own purposes and not those of the broader society. I think it's still an open question whether there's going to be robust competition for these AI markets. And it's still an open question about whether today's tech companies are the ones that are going to be able to extend their market power into these emerging markets. To start with, there is genuinely good news on AI and competition. First, there is currently competition for the next generation of innovative AI tools. Now, it's true that might be like that 1996 magazine where there were 30 different browsers. But we do have established tech companies building their own internal AI tools like Google, Apple, Amazon, Palantir, and Alibaba. Meta has made their model open, presumably hoping to profit from the compliments. And a number of recently founded companies have built large-scale and effective models, including OpenAI, Anthropic, Mistral, and DeepSeek. Many other companies are developing specialized AI tools in autonomous driving, banking, healthcare, graphic design, etc. Second, there are not economies of scale in the textbook sense. The models are built on data, and the law of large numbers applies. In your stats class, if you took one, you may remember that predictions improve in the square root of n. What does that mean? It means, in general, the 100th observation in a statistical exercise will be more useful than the millionth, which is more useful than the billionth. So yes, these tools require an awful lot of data to be useful, but at the margin, there are decreasing returns to that data. Nevertheless, there are big risks to the future of competition with AI, and I'm going to highlight 3. The first one is what we call endogenous sunk costs. The second one is regulatory entry barriers, and the third one is complementarities between layers of the tech stack. I'm going to go through them one by one. Endogenous sunk costs. This is an idea from John Sutton. And the idea is when an industry begins, entry might be easy. But over time, as a small number of firms compete, their products get better and better, and they get more and more share of people's mind, to the point where for a new entrant, they may need to spend not just thousands or millions, but billions. And so Sutton argued that this occurred in technology industries like chips, and there's reasons to think that this is going to lead to not monopoly, but oligopoly in the context of AI. The second point is something that I think I'm going to have, many of you might disagree with, although I think many of you might agree with, which is that there is a trade-off between other aspects of AI regulation and competition. And the trade-off arises for a few reasons. One of my roles is that I help run an incubator. And when I see these startups, even small administrative costs deter entry. Every time you tell a startup they have to talk to a lawyer, they get scared. It is a big deal, not a little deal. Second, AI regulation often touches on privacy. And restrictions on data flows tend to help companies that have lots of data and hurt companies that don't have that much data on their own and need to access other companies' data. And there is plenty of evidence that privacy regulation reduces competition. Furthermore, if liability risk is high, business customers might often choose established companies. So there's this old saying in the computer industry that nobody gets fired for buying IBM. And Garrett Johnson has pointed out in the privacy industry, in the ad tech industry, that nobody gets fired for hiring Google. Because if something goes wrong on liability, you can say it's Google's fault because they know what they're doing. Okay. Third, AI is a complement to many other information technologies: office productivity software, cloud services, user interfaces, computer chips. And the largest tech companies have already used monopoly power in one domain to favor their other services. That's what we've heard about all day today. And that in turn gives them monopoly power in new markets. They're likely to do it again with AI. For example, we could see large cloud providers forbid potential competitors from training and applying AI models in their platforms. We could see the developers of operating systems limit distribution of competing AI companies. We could see self-preferencing in similar ways. This is a domain where antitrust authorities need to be vigilant, and legal scholars like you need to do better at developing theories of harm and potential remedies. So to sum up, I think AI has a very good chance to be the next general purpose technology to transform the way we live and the way we work. And I'm worried that something holding back that potentially fantastic future will be a lack of competition.
Eleanor.
So thank you, and thank Harry and Andy for this terrific conference. So Scott, you kept me up all night thinking of what kept me up all night. And two things I realized keep me up all night. They're little downers, I have to warn you. Okay, so the first one is, it's the very big picture. These companies we're talking about, the big tech companies, the biggest three are the three biggest companies in the world. They have more than 3 trillion capitalization. They operate without bounds to geographic markets. They're Uber competition. And we are like Lilliputians thinking that we can call them to account and we can regulate them. So Europe is actually most advanced in doing the regulation. In its case regulation, it imposes the biggest fines ever, plus some behavioral fines. And it's a drop in the bucket. It does not deter behavior. Meanwhile, all of us little Lilliputians are trying to think of the best rules or the best remedies, and they're all different. It's a Tower of Babel. And the increasing nationalism in the world feeds into the differences. That is, we do not have norms that can be generalized to say, these are the things that big tech, the biggest gatekeepers, should not do, much less, and we will call them to account. So that was my number one. There's a very big picture out there, and we may be thinking of these great ideas, and they may even be great ideas, but when we come back in 15 years, what will we see in the landscape? Will we see that the US remedies have made a difference? US, incidentally, being the least interventionist of the mature jurisdictions that are making rules. Will US have made a difference? Will EU have made a difference? Will these firms have $6 trillion capitalization and no way to control the Goliath? So that was my number one, just to think about that, but to think about it more seriously in terms of there should be better collaboration among the jurisdictions to try to derive common norms, at least to be able to say, these are the anti-competitive conducts that you should not do. And then it will fall to each jurisdiction, of course, to carry that out. So my second point of concern that keeps me up at night, very relevant to Microsoft. There will be a time when one of these cases goes up to the Supreme Court. Maybe 4 years, do you think? And maybe it'll be a Google case, maybe it'll be a Google search. And I can imagine an argument before the Supreme Court when, just say, Justice Alito looks at plaintiff's counsel and says, I see you are relying on Microsoft. I see these cases are relying on Microsoft, but it's the wrong Microsoft. We rely on Novell against Microsoft, the decision which, of course, Judge, now Justice Gorsuch wrote. And that decision has totally different music in the background. And it is the decision about when Microsoft when it was doing beta testing for, I think before Word, yeah, this was before Word, and Novell made WordPerfect. WordPerfect was good. Everybody liked WordPerfect. Microsoft was giving Novell for WordPerfect the interoperability information that it needed to be the most integrated with Windows. And then Microsoft decided to make Word and dropped the interface information. And there's a memo, email, I think, of Bill Gates saying, we'll keep them at bay for a long enough time so that Word will get sufficient traction with Windows, and it'll be very hard for WordPerfect to catch up. Is WordPerfect dead or dying? I don't hear about WordPerfect.
The company still exists.
Right. So Gorsuch wrote the opinion saying, this was just a refusal to deal. Doesn't come within Aspen because it was only beta testing, so that there wasn't a considerable continuing refusal, continuing connection of working with Novell, and repeated, because Trinco had happened in the interim, repeated a lot of the words of Trinco, and said, we really, especially in these fast-moving markets, we must make for an error of non-intervention is much better than the error of intervention. And so if the Novell version, which is very, very sympathetic with Trinco, if the Novell version is the version that prevails, we will probably have very little monopoly law left in 15 years from now.
All right, very sobering, Eleanor. Luke, your European regulatory efforts, I guess, are no more than a drop in the Atlantic Ocean, which I understand you're renaming England's pond. What keeps you up at night?
Well, thank you, Scott. And I should mention, it won't have escaped the eagle-eyed amongst you, but I am deputizing for my colleague Thomas today, who very sadly can't be here because he is too unwell to travel this week. I should add, though, for his protection as well as the firm's, that the remarks I'm going to make now are my own and don't necessarily reflect anything Thomas would endorse. I should also add that I'm very privileged to be on a panel and actually in a room of such distinguished academics. As Scott mentioned, my interest in these areas comes more from the practitioner perspective, principally at the moment relevantly in the two Google cases that I'm involved in. But I also, somewhat reflecting Thomas's background, will hopefully be able to bring that perspective, but also the European dimension to this panel. With that all said, I'd like, I think, uniquely, to deal with the first of Scott's questions, just the optional question, but only really obliquely, which is to say, because I think it was directed at whether or not US law and enforcement should pay more attention to Microsoft, but the Microsoft Teams situation does seem to me to be a good example of an instance of where interoperability as a remedy is particularly important and apt. And also, I mean, it's a scenario where there was tremendous demand and the market did respond. And I don't want to go into details of the issues at stake in the Teams case and the bundling there, but it seems to be the kind of situation that an ex-ante regulator is very well positioned to deal with, particularly in an unusual situation such as COVID, where the market might need a speedier response, might call for a speedier response in the interest of consumer welfare or competition, or however you want to analyze it. It does seem to me to be an example of where the tools that are available elsewhere may not be as apt at solving problems. But that's a topic to which we can probably return because obviously everything's up in the air at the moment, and we in Europe are going to conduct a natural experiment about how ex-ante regulation works. But we've been considering today whether or not the ex-post tools that have been used here have been effective. And that leads me on to kind of my second point, the first of the two things that keeps me up at night. And from the kind of practitioner perspective, I think the thing that does really bother me at a practical level is the effectiveness of the tools that we have. And it was very interesting to hear on the first panel the debate about whether or not people felt that the Microsoft case was handled too quickly, whether that was a positive, or whether it went too slowly. And I think, a bit like Goldilocks, my take from the debate was that perhaps it was just about right in the end. In Europe, we have had attempts at regulation that, even when they did result, and it took a very long time for them to resolve, may only be drops in the ocean. We certainly did very little for a very long time, and now are doing a lot all at once. We have the DMA, which is now being implemented quickly. We have the DMCC finally in the UK, which the first investigations are now on foot and are going to resolve in 9 months. And we have litigation. We have the collective proceedings regime in the UK, and my colleagues are currently litigating the first tech collective against Apple in the App Store case as we speak. The next one is against Google in the Play Store proceedings in the autumn. So I think we'll see, in terms of a natural experiment there, whether it is too much, too little, or just right very soon. But the first thing that keeps me up at night is whether or not the tools that we have are being deployed effectively. And in the UK, the DMU took 4 or 5 years to come from inception to implementation, which really, in my view, is too long, and that was to do with political priorities, legislative delay, and the DMU was literally staffed and waiting for almost 3 years before they could do anything. And that brings me on to the second thing that keeps me up at night, which is the presence in the antitrust conversation of the political conversation. And that's clearly a relevant factor here. Exactly how it's going to play out remains to be seen. But just in the UK, we've recently had the chair of the CMA dismissed 2 years into his term of 5 years, replaced with an industry figure formerly at Amazon. We have had the CMA and other regulators called in to explain to the government what they're going to do about growth. And we have officials in Europe for the Commission commenting in response to remarks made by the Vice President about political priorities that relate to how enforcement priorities are going to be changed in response. These kind of issues do seem to me to be concerning because, I mean, today we've seen you can have a very interesting debate about antitrust enforcement and valid perspectives at two different ends of the spectrum, but that's an analytical and helpful debate that sets out parameters that people can follow, whether or not you're responding to investigations and cases or whether you're pursuing them. But as soon as you have the political debate in there, the antitrust debate becomes academic in the pejorative sense of the word. So that's, I think, the final remark I just make at the outset about what I hope to see or what I worry about in the future.
So there are a couple points, Luke, that you and Avi made that are ripped from the headlines, as it were, if it were an artifact, if it were a newspaper, whatever. Let me take a very recent event to focus on some fundamental questions, including, when big is bad, whether competition is the best way to spur innovation, how central the consumer welfare standard is. We recently learned, and you heard it in Avi's remarks, that DeepSeek, a Chinese AI company, is able to train and run its large language model without access to NVIDIA chipsets at low cost, high efficiency. We've seen the announcement from the White House of a $500 billion AI infrastructure project. I'm I'm getting all of our blood pressure up thinking about this, right? With the heads of Oracle, OpenAI, and SoftBank right there. And in Europe, however, I know that the concept of promoting national champions, often by consolidation, companies that can better compete abroad, is not, pardon the pun, is not a foreign one. President Trump has said that the US cannot lose the AI race. So I'll start with you, Luke. Might we and should we see competition laws relaxed in the interest of national competitiveness? And if so, should that concern us?
Well, I think my answer, my straightforward answer to that would be yes. But the interesting dimension, somehow in the UK, we managed to get it the other way around, in that there is pressure to relax competition law and in particular merger law from the government. But it is not to promote a national champion. It is apparently to promote inward investment and is particularly in response to the other Microsoft Activision Blizzard prohibition of last year. So at the moment, I think we are seeing initiatives to, let's not say relax competition law, but to prioritize other issues. But we're not seeing it in the promotion of national champions. We're seeing it actually in the promotion of other political ends. Now that, I think, is equally potentially problematic because my sense, I imagine it's a familiar sense in the room, is that what promotes innovation, productivity, is the proper application of competition law, untrammeled by other interests, and that's what's most likely to promote consumer welfare. Once you start promoting the interests of a national champion, it's akin for me to protecting competitors. The country perhaps is the proxy for the competitor, but the particular competitor is being promoted over competition and outcomes. And so I think, broadly speaking, it's a negative if it does happen. However, all that being said, I do think that there are other priorities that might compel such an initiative and that might be more justifiable, such as national security. And in the field such as AI, I can well imagine quite a compelling argument that you might want to have a national champion. I mean, given what we've seen over the past few years, due to the awareness of the reality of data transfers, if you have a dependence within a country on external companies or externally based companies to run your key infrastructure, key competitive infrastructure, that could be a problem from a number of other perspectives. But just from a competition perspective, just from a perspective of welfare, I don't think national champions are a good idea.
Avi, your thoughts?
I think we want competition, and I think competition is one of the strengths of this country. I come from a country, I'm Canadian, where we tend to have one tech company at a time. It's kind of exaggerated, but not really. And they make the wrong bets sometimes when you have only one company as a national champion. BlackBerry seemed great until it wasn't. Nortel seemed great until it wasn't. And so one of the strengths of the United States is this incredible competitive environment. And the focus, in my view, of antitrust should be on maintaining that competitive environment in this country and not to decide which technology is most likely to win.
Eleanor?
So I agree with my colleagues on the platform that competition is what creates the competitiveness. However, I mean, as we all know, there is this huge, whether it's movement or rhetoric, to say we're really afraid that antitrust stands in the way of competitiveness. I think it's almost always in a particular case, like take Siemens Alstom, I think it's a good example, a merger that would create a lot of market power. It was not argued this way with competitiveness defense at the time, but I think that Europe is opening the door, so another Siemens Alstom would be argued this way, that let the merger happen, because if you prohibit the merger, you're going to let China come in. these are almost always false facts, but I have a solution. The solution is for any jurisdiction, and US doesn't allow the argument now, and I don't think they will, even though it comes in by way of a whisper campaign, I think. But this is my solution. For any jurisdiction that's going to allow a competitiveness defense, I say let's open the door to a competitiveness offense. All of these mergers, big mergers, so inefficient. They fall by the wayside if they're not prohibited. They're often both anti-competitive and inefficient. Bayer, Monsanto, AOL, Time Warner, a whole stream of mergers. GE, Honeywell, which Europe prevented from happening. A whole stream of mergers are so big they're inefficient. So if you're going to let competitiveness come in as a concept that may be defense, it opens the door the other way around for the competitiveness offense.
Erica?
Just to reinforce, it sounds like we all agree up here that sort of this national champions model is not a good idea. But I think since we wrote the outline for this panel, the DeepSeek news has been eclipsed by the US technological marketplace when Microsoft announced topological qubits this week. So there's this brand new invention that they've come up with. And so if you thought gas, liquid, and solid were the only states of matter, then the technology industry in the US is disproving that. And so I think there's just no answer other than competition, and that's already happening on our outline here.
So we've heard concerns throughout the day about content moderation. There's now nascent litigation involving the use of AI and making use of journalists' work product in different ways and without compensation. We know where millennials obtain their news from the internet, which makes them the platforms, the gatekeepers for the next generation. We worry about disinformation, about misinformation, about democracy at the same time as we worry about free expression and Justice Holmes' marketplace of ideas, which is a very long windup to another general and specific question pair. What role should antitrust play in content moderation issues that arise in this context, if at all? And if you like, given we have 3 venerated professors here and a European practitioner, can and should antitrust save the world? Or is it an appropriate tool to use to address some of these issues? And I will proceed on a FIFO basis, and you will go first, Erica.
So I'm surprised how much airtime this question is getting, and it makes me think just because we have an antitrust hammer doesn't mean everything is a nail. The best I can say is that some of the interests that antitrust law pursues might ameliorate some of the concerns in the content moderation debates, and that's the closest connection I can see here. So if we seek to ensure that markets are open for competitive content provision and that there's some transparency in what moderation occurs by virtue of competition, then perhaps some of the content moderation debate goes away. But and maybe to a small extent in sort of case selection, I guess, by agencies. So if content platforms are engaging in anti-competitive conduct and they choose that as opposed to some other case. But I don't really see it that strong of a connection. I think we have given it enough airtime already today.
Avi, any thoughts?
I think I agree with Erica. Thinking about antitrust policy for competition seems first order. Once you start trying to do other things, I think it'll muddy your ability to enhance competition.
Luke?
So, I mean, I think it is, there's a sense that, every problem to an antitrust lawyer looks like an antitrust problem. But I think there are some important kind of necessary conditions about some of these problems that can be solved by antitrust. And when you look at something like not paying for content, taking content, a lot of that derives from market power. So if you're looking at a dimension of the problem that is really driven by market power, I think that is an antitrust issue. And certainly in the UK, it's a lot easier to enforce antitrust issues than it is some other issues, and that's another procedural dimension to the whole question, which differs from jurisdiction to jurisdiction. But when you're talking about other more policy-related issues such as media plurality, I think you have to leave those kind of issues of policy and principle to their respective fields. And once you've dealt with the necessary condition of having a contestable market and having choice, which is an important sort of starting point, but not the end point, I think then it is more properly, these issues are more properly dealt with under their respective regimes.
Eleanor, any thoughts?
So I have some thoughts. I agree with all of you, but I wanted to raise a couple of different nuances. The first I wanted to say is that it's very interesting, and we talked a little bit about this at a prior panel, that there is a conservative Republican group who call themselves conservatives, who are they recognize the power of big tech, and they want to be aggressive against big tech, and they'll go for using antitrust against big tech just to be aggressive against big tech because they accuse big tech of screening out conservative views. Do we want to keep that sentiment on board or sever that sentiment? There was one very interesting concurring opinion of Justice Thomas in 2021 in Biden against something First Amendment. Sorry, I can't think of the first name of the defendant. And the case had come up to the Supreme Court, and the court had held it moot, I think, and nonetheless, Thomas wanted to write an opinion. It was about whether Twitter could disenfranchise Trump from being on Twitter way before it was a sparkle in the eye of Musk to own Twitter and change it to X. So it was a free speech case. And a question whether big tech has to be bound by free speech rules because it's not government. At least it wasn't then. It might be now. I mean, is X government now? I think maybe it is now. But in any case, the opinion by Thomas says these big tech companies have so much power. They really control our lives. There's something called a common carrier. I think that they are in this category. I mention that because it's just a very interesting opinion that should and could be imported into questions of antitrust about big tech and power.
The intrigue is fascinating. All right, let's shift gears for a moment, talk about current litigation and remedies. You're all welcome to take this anywhere you like. Which DOJ case against Google is more important? Search or ad tech? If divestiture of Chrome is not in the cards, what do you think about requiring Google to share search data with rival search engines? What other remedies may be appropriate? And the $64,000 question, Eleanor, you brought it up. Which case, if either or both, winds up before the Supreme Court? Luke, you're excused, but I'll turn to you at the end if you choose. Avi, any thoughts?
Okay. I'm going to take that share search data one. I want to
Okay.
talk about that, which is that that sounds in many ways like interoperability. And generally, that is pro-competition and seems excellent. But it runs head-on into privacy. And so the increasing evidence we have that privacy is at odds with competition, that's another sort of manifestation of that, right? We want openness. Openness is a good value. Privacy is also a good value.
Because I've now given my
And-
information to you
Yeah,
and Erica.
and
to
they're
compete.
effectively opposites. And we have a real challenge in a world where we do care about, or people do care about privacy, to have the government come in and say, no, you know what? Your Google searches now can go to any competitor who wants that information.
Erica.
Timely. All right. So that was about 8 questions, but which case is more important? I guess by measure of the impact on the business, I would say search, for whatever that's worth. But I think the remedies question is a much more interesting one, as we've heard today. I think it's one of the greatest and most intriguing challenges. It's like, what do we do with search? And I have to say, I think like saying privacy is at odds with competition is not untrue, but it's also not a total answer to that dilemma. And I think you kind of have to start with what the actual law is. So like it's well settled that the scope of antitrust remedies might go beyond the prohibition of whatever the practices were that were unlawful, but they have to be tied to competitive effects of the conduct. And so I think that asymmetry is kind of interesting to think about because in Microsoft we see it, right? Like the violation wasn't denying rivals access to APIs or server protocols, but the remedy requires that sort of access. And I think that, I think a lot here of sort of, I know Bill's still in the room, but Bill Kovacic and David Hyman have this warning against like leveraging agency power from sort of one policy domain into another when you're trying to obtain remedies commitments. And so I think that I would agree with them that if what we're seeking in the Google search remedy is just like better privacy, that might be something we want to think carefully about and be a little bit careful about opening up that sort of window. But I think that there's a narrower version of a role that privacy can play in the Google search remedies. And then there's an important distinction to make there. We can say, well, we're intervening in a market as antitrust folks. How do we do no more harm than necessary to privacy? If we have option A and it restores competition and it's terrible for privacy, and if we have option B and it's a little bit better for privacy and it still restores competition, then why wouldn't we be smart in our design of the remedies and choose the less privacy impactful one, which I think exists out in the world. So that sort of design freedom, I think, is something that can be brought to bear and doesn't really show up that much in the proposals for final judgments so far. I think that the other thing to think about, and maybe sort of an answer to Ari, is there can be positive privacy side effects from remedies that target competition. Okay, just coincidentally, like a side effect on privacy. And here I think of the EU remedy when Google acquired Fitbit was to sequester the Fitbit data so it couldn't be used for advertising, and that was driven by competition concerns. Guess what? That sort of a data silo might also accrue to us beneficially for privacy. So I don't think that they're always in conflict is really a full answer to what we need to do. And if I may take one more minute, I have a lot of opinions on the Google search related stuff. Yeah.
In the spirit of Harry first, you have 45 seconds.
You have 45 seconds. So I think that there are some very specific things we could do to sort of bring together these two policy worlds in a way that makes sense for antitrust law. Maybe have a technical committee that has some privacy skill set. Okay, the technical committee right now is software, AI, economics, but qualified buyers in the proposed remedy would have to meet sort of privacy and security standards. Who's going to figure that out, right? I don't think that is a conflict between the two areas of law. And second, and I promise last, I think the companies that receive our personal data, because some of the data that's contemplated in the remedy to flow would be our personal information. Think of the things you've searched and where you want that information to go. Okay, some of it's personal data. So could the recipients have to agree to some sort of privacy protection? And here I think bankruptcy divestitures are actually a really rich source of information, okay? So when there's a bankruptcy sale of personal data as an asset, the buyer might have to agree to either reasonable privacy protections or at least to uphold the privacy policy of the seller. So those sorts of things where you might still be able to move the data, but have some sort of use limitations that reasonably protect our privacy. And I think that's relatively non-controversial. Tell me otherwise, Eleanor.
No, I won't tell you otherwise. I just take it from there. And I have something to say about search and something to say about ad tech. I think the ad tech case is a more significant case even than the search case. And that is because it just goes to the gist of conflicted structure of the market. And because Google is the bottleneck, the supplier, and the buyer. And the logical remedy there is divestiture, which may or may not happen, but if it happens at all, it would be in ad tech. So I see that case as very large in terms of the structure of industry as a barrier to competition on the merits.
And for Google, because the remedy is potentially more
Oh,
draconian.
right. And for Google search.
Buyer, seller, broker, that's verboten.
Yeah, right. I mean, it should be astounding. They should know not to do it. In fact, we talk all this time about remedies. The best remedy is not to have to get to remedy. I mean, we should have strong rules of law that companies abide by, and we don't get to these remedies. So just a word about Google search. Google has this very strong argument, which the judge Mehta keeps emphasizing, which is Google is the best, and that Google got to its position by being the best. And yet we know that it has, again, as the judge says, citing Microsoft, it's closed off the best and most efficient channel for competition. And what it did was wrong. But I am very concerned that when it gets to remedy in this new stage, and with all that big tech has done to make the president very pleased with it, when it comes time, which is in about a month, for the Justice Department to file its revised proposed relief, it's going to look really different from the one that Jonathan Cantor filed. It's going to, this is my fear, it's going to look a lot like Google's proposal to simply prohibit what was illegal. And if that's the case, it's almost a Pyrrhic victory, because Google already has locked up the market. And if you open that little window of the market, people are still going to choose Google. So nothing's going to happen. I think that Google search probably will be the first one that gets to the Supreme Court, but you can't tell now.
Okay, so we heard quite a bit from Slade Bond about the tenuous position in Congress now and the interesting makeup of the Republican Party in the Senate. We've heard sort of near black letter characterizations of Trinko on the one hand and Aspenstein on the other, and throw in, Image Technical Services too, and trying to make life cycle cost assessments in the foremarket. And now we've heard some very interesting, I'll characterize them as proposals, Erica. So let me ask this question. Will our current laws, not to have to predict, will our current laws, in your view, be adequate to enable us to promote both competition and entry, as well as innovation, protect both privacy and expression, and advance consumer welfare, and there include choice along with output and price, at the same time in these markets? Erica, you get the pleasure of answering this very simple question first.
But it's beyond antitrust law that you're asking, right?
Yes.
Yeah, I think privacy law is inadequate in the United States right now. You just need to look at 135 other countries around the world that have federal omnibus privacy law to see that. So I think that's a simple answer. I'm not advocating for privacy to be achieved through antitrust law. I think it's just popping up in all of these cases. Is our existing law adequate? I think we need to think about, maybe this is just not really law so much as institutions, like how do we interface between these two areas of law? I think that Bill's right that the FTC is a really unique institution and that it has so many authorities and is really underachieved when it comes to thinking about cross-silo implications of these areas of privacy and antitrust law. So we could be really excellent at it and haven't really done that. And I think too, if I was going to ask for one other thing in existing law, it would have to be, and this came up a fair bit today too, like clear analysis of pro-competitive justifications, because the pro-competitive justification, so if Microsoft didn't present very many. Now the technology companies of today have realized they need to have a justification. Guess what they're choosing? Privacy and security. How do we deal with that in the law? And I think that's a very nascent question that I have many ideas on, and please read my paper from Notre Dame on that. Thank you.
Eleanor.
So first, let me take on a cluster. You had a cluster of values. Can our law do everything at the same time? First, I want to put data and privacy to one side because that comes into conflicts. I want to say that all of the others can work exactly in the same direction, and that is protecting competition, entry, innovation, and consumers. The innovation question is a big question that some of you in the audience have written a lot about, and the difference between the Schumpeterian and the Arrow points of view, with Schumpeter on the side of saying you need extra profits to put into R&D, and Arrow saying you really need diversity to create the dynamic competition. I think, first of all, that debate's not going to be settled. It's a case-by-case matter, but I do think it's clear that the incumbent has the incentive not to cannibalize itself, and the entrant has the incentive to break as much as it can. And therefore, that always has the edge for me. So I think, yeah, competition, competitiveness, consumer welfare, we want our law to serve consumers, of course, and innovation, we want it all to work together to the extent possible, and it can.
Luke, any thoughts?
Well, I'd just like to pick up on the question of data, because I think it is a really interesting parameter of competition that at the moment is very difficult to deal with. But it's partly because we just haven't got our heads around it in the same way that we've got our heads around things in other parts of the economy. And I don't see inherently any reason why we couldn't have a tractable way of dealing with, and in particular valuing data and privacy in a quantitative way, not just a qualitative way. I think the reason why this is so important, I mean, it's partly just inherently, is it's a necessary condition to be able to do private enforcement. Because if you don't know the value of the data that you said issue, it's very difficult to bring a claim for damages. It clearly does have a value, we just haven't got there yet. And that's one way in which economics could, I think, develop in a very helpful way. If there are any people in the audience, by the way, who do have good models for valuing data, I'd love to talk to them afterwards. But I think more kind of analytically, just on one of the points you raised, Scott, about the image technical case, the usefulness of being able to value data could act in both directions. It could solve problems for incumbent companies as well as assisting consumers, because if you're trying to figure out the cost of using a product, and the cost of that product is your data, there's no way you can engage in a life cycle cost analysis at the outset when you're thinking about whether to sign up to Facebook or some other product that's basically going to monetize you just through your data, not in other ways. At the outset, if you have no idea what the value of that data is. It could be extremely helpful to consumers in consumer choice circumstances if you could, at the outset, have a predictable data quantitative model that allows you to know, I mean, me as a certain type of consumer, perhaps you can even get individualized pricing, which some people would think would be a bad thing, some people might think is a good thing, but you'd actually have a tractable way of dealing with data as a parameter of competition. Whereas at the moment, we all know it's important, but we can't really get to grips with it in all the different ways we ought to get to grips with it to be able to answer some of these questions.
Avi, I don't want to cut you out.
Okay, just a quick comment, which is, you talked about competition and then other things like privacy and expression. And as in my opening remarks, I said we do have competition, at least for now, in language models and AI. And that competition, I think, also manifests in different points of view or different expression. Grok is a very different model than ChatGPT. And so we have competition on points of view, at least for now, in AI. I don't know that we will still have that competition for points of view 5-10 years from now, but as long the competition seems to be creating incentives to have different points of view. And so competition, I'm not sure we want to think about both, but if we address the antitrust competition issues, many of the others will follow.
All right, you said 5 to 10 years from now. So we have a very mercurial chief executive with a populist base. We have a vice president who is viewed as a conservative. We have a vigilant incoming AAG. We have a chair of the FTC who apparently is perturbed with the American Bar Association. We have very, very active state AGs, one of whom I saw earlier, and we have private enforcement. A lot of different streams to think about there. So, what do you see for big tech, not just in the next 4 years, but over the next 10 years in terms of enforcement trends? And Eleanor, I will start with you.
I might be a little depressed on the subject. I don't want to convey that because I'm very upbeat on antitrust. In 10 years, if we consider what will probably be the outcome of the cases that we've started now, for example, I don't have a very satisfying prediction. I think that Gabriel Kalko wrote a book many years ago called The Triumph of Conservatism. I think that conservatism is triumphing, and it's a conservative nationalism, which is much worse than just conservatism, that's triumphing. And I would not predict another US against Microsoft to come out of the litigation. And I think I'll stop there because, again, I'm very upbeat on competition and antitrust, and I don't like to see myself in this down the road.
Erica?
I want to cheer you up, Eleanor. And we
Good.
have a saying in Canada, since we're going with our Canadian identity here, if you think you're too small to be effective, you've never been in a sleeping bag with a mosquito. Okay, so go forth and be the mosquito. I think we've heard that technology changes so quickly and unpredictably that it's sort of ill-advised to make 10-year predictions. But I think in the sort of foreseeable future, I am always surprised by the lack of attention to cloud computing, which, to the FTC's credit, they've now done a study on. But it's such a hidden but immense source of power over content and commerce. And it's so concentrated that it just seems like an obvious area for attention, if there is any, to your point. Yeah, and then I think in the immediate term, we're going to see a retrenchment of some privacy-related enforcement, but I think that children's privacy and sort of privacy and fraud remain popular regardless of who's in power. And over the longer term, I would expect privacy law to inevitably get stronger.
Avi, we all have very limited tunnel vision, except for you with respect to AI and tech.
Okay,
Where
well,
will we be?
I can talk about the economics, not so much about the law. So I think there's a lot of challenges around what you might together consider distribution channels. So that includes operating systems, that includes cloud, and that includes devices potentially. And so to the extent that those that control the operating systems, cloud, and devices are going to be able to throttle the application layer, that's something to worry about. And I'm confident it's on many people's radar. I have no idea how that will play out with a particular administration.
Well, I mean, picking up on that, I mean, the way, and so I should step back for a second. My overall prediction for tech for the sphere is an optimistic one, to take the contrary view to yours, Eleanor. But maybe it's because I have a bit more of a European perspective. In that, just picking up on your point, Abby, I think the way in which this can be dealt with effectively can be, we'll wait to see whether it is through a kind of ex-ante nimble, pro-competitive regime to ensure that the gatekeepers don't squish innovation, don't hog the market for themselves, keep key services interoperable. That should be possible under that kind of regime. And the focus is there. So I think we've got a chance. We need to wait to see whether it works, but that does make me optimistic. It also does make me optimistic that those kind of regimes are not about something that is potentially very destructive. They're not about busting the companies in something that potentially has wide ripple effects we can't predict. That does mean, I think, good news for incumbents, whatever you feel about that. But I also feel, and in this respect, I think my view of the optimistic take is probably less important than yours. And I think the real action is going to be here, and how particularly the search remedies play out, but then with similar cases that come along, whether or not those remedies can be designed in such a way, whether they're implemented in the first place, but then once they're implemented, they stick and they seem to be a success. If that's right, then again, I don't think this is an existential risk for the big tech entities, but I think competition will be fostered much in the same way, arguably, it was fostered by the Microsoft decision and the ecosystem around it flourished. I know that I'm not necessarily an accepted proposition, but I've felt from the discussion today that's been a kind of a consensus view. And that's kind of where I feel, we could come out, but I think it depends very much on what happens here in the next year or two.
All right, I want to leave time for questions since we have 4 minutes left, but I decided just to write down in bullet point fashion some, lightning round questions, and unfortunately, those bullet points expanded to 4 pages over the course of the day, so there was a lot of information. Some of you have answered them already, but indulge me with one before we open up for questions from everybody else, which is this. Microsoft to trial. Now, this is now looking forward and to appeal. Consider everything that we've heard in terms of getting it fast, getting it right, how the market changes. Too fast or too slow? You each have 15 seconds, no more.
The Microsoft case,
Yes.
US against Microsoft.
Yes.
They got it right, it was fast, it was good.
All good.
Javi?
I have no idea. All good.
Okay.
Yeah, I agree with Ellen.
All right. We'll open up for questions. Mike? It's coming.
So I wanted to bring your attention to an issue that came up.
I can hear you.
Can you hear me? I'll speak louder. So I want to bring your attention to something that came up in the Google search case that occurred last year, and which we think has a bearing on this. We filed a lawsuit on behalf of online news publishers. And the contention that we made is that Google is leveraging its power in search to take over online news in the United States. It currently has about 67% of that market. It has made deals with major publishers like the New York Times and the like, whereby they get a percentage of the news it digests and redoes. The way it works is through Gemini and AI. If you do a search on Google search for a particular thing, what will first come up is a Gemini article, crafted from the news it obtains from publishers, often through this LLM management. And so the small publishers in particular have suffered greatly. 80% of the publishers in the United States, measured by company, have gone out of business in the last 10 years as a result of this. Google, we believe Google's intention is to take over online news. In December, or actually in September, Judge Mehta held a hearing on what would be coming up, the upcoming trial. And here's what he said. He said, AI was not really discussed during the merits trial, but guess what? I now, having acquainted myself more, think it's probably a central piece of that trial. And therefore, I want a lot of evidence presented at the remedy hearing on that. I'm ordering further discovery to the Department of Justice on AI and how Google uses AI, because I think that may be a critical issue I have to decide. What do you think?
I'm not sure what the question is, Mike.
The question is, given the fact that we've discussed AI, What role do you think this
make
will
a
play in the
empirical thing?
relief?
So just the timeline that you just described doesn't make sense to me, which is if local news declining at least 10 years ago, and I actually think it started to decline in the 1990s with the national expansion of the New York Times, how can that be because of Gemini? So like there's just, I'm sure there's a timeline you have that you're describing, but even what you just said seems like we can't blame Gemini for the 1990s. And we
can't blame
can't blame
Gemini
Gemini for even the expansion of Google News up until 18 months ago at most. So when we think about harm, I think it's in stuff that's happened already. It's important to think through what's the technology or competition we're worried about here.
I think initially Google got in as a result of being an aggregator of news, whereby it would present the news at its aggregation sites and then allow you to go to the website where the news was sourced. The way Gemini works is Google presents its own summary of the news, taken from scraping various websites, and there are links. The links take you to further Google discussion, and at the bottom of the page is the news site that is the source. And that's had a pretty devastating effect over the last year or so.
Okay. Well, I invite you to continue at the reception, but I don't want to cut off questions. I see Tim in the back.
So I'm not actually going to ask a question about Google. I had a question. I see there's a lot of Canadians on the panel. And by the way, boy, we did a good job in that hockey game yesterday. I just want to mention that. But besides that, I have a question. There's a serious question about the national championship argument in industrial policy and antitrust. I hear everyone reflexively saying, obviously, for national championship policy, it's pretty bad track record. And the research, when I was on the panel, the research and the economic history of challenging monopolists and then letting things grow is very strong. Mind you, those are mainly in the United States, which has this enormous economy, lots of venture capital, a lot of opportunity. Do we have different answers in small countries, smaller economies? I'm not trying to advocate that Canada should pour out all its money into a search engine or something like that. I think that would probably go badly. But I just wonder, is it quite a bit of different answer in smaller economies, and what is trade more of a factor? I just wonder if either of you or anyone who's not American has given this some thought.
I think there is a different question in small economies, and it's not you wouldn't necessarily have to call it national champion, but to have a firm that is scaled up to compete well, efficiently well in international markets may require the acceptance and toleration of some market power at home. And that's the way I would frame it, not to be a national champion just bulking yourself up with market power, but being able to compete sufficiently well.
Maybe I can overlap it a little bit with the answer we didn't quite get on the diversity of news. I think there's more willingness to regulate to protect culture, and that sometimes sort of manifests as protecting national champions.
Right.
So, for example, you have to have sort of a certain amount of Canadian content on the radio, and so you hear Celine Dion a lot.
I should have mentioned Michal Gal in my own statement because she's written a lot about this.
Okay. One more over here.
Wonderful panel. Thank you very much. I think we all agree that data is important in the digital realm, and it's becoming more and more important. And there were very interesting discussions with regard to privacy. But I think that there's another element here, which is trade secrets. There's another, and actually, trade secrets might limit even what I call secondary uses of data. That's actually what's argued against DeepSeek, because DeepSeek is taking the results from the large use of LLMs and then taking the results and learning from the results of other models, which is, I call it the secondary use. But you need the data to start with, so that firms like OpenAI come and say, well, this is our trademark, trade secrets, so you're not allowed to use it. So if that is accepted, then it means that the entrenched power of those who already have very large amounts of data are going to still have a lot of power. How do we go around that?
Well, I think for me, this is a reaction, and this is partisan, but I mean, I think it's astonishing chutzpah. But it demonstrates the fact that those businesses appreciate the power of the aggregated data and the data that they have been basing their models on, which is just as valuable to the people who produced it. Either they didn't have the market power, didn't have the appreciation of the value of what they had. And I think it's been a very interesting development. It links to the kind of case theory that Mike's talking about. It's interesting the CMA is now looking at this aspect in its search case. It's also looking at the extraction factor, particularly in relation to news. But it's been, I think, a welcome development. I mean, you can take whatever view about whether there's a greater value to the trade secret of the aggregation of data on the LLMs or the original content on which the language models were based. But I think it's just an interesting development, but it's not one that necessarily puts an end to the collection of data. Maybe it just starts to get us towards, and this is also in the Digital Markets Competition and Consumer Act, some kind of negotiating framework whereby people then, instead of it simply being a kind of the powerful will take, you actually have a framework in which you can start to license this material and start to get an understanding of what is the value and how can you have a kind of organized way of value transfer in this marketplace.
So my thanks to a terrific panel, and I think, Harry, do you want us to stay up here while you and Andy tell us what we've learned? No? Okay. Thank you all.
Thank you all.